Yeah, so there is no need for you to say it. There is no need for it. It is in their head. They will say it. It is them to determine.
Well, that is his proposal. So if there is a counter proposal, yes.
So
Any further proposal or counter proposal not to include in good faith? Leave it as it is. Honorable Minister, do we have your views on that? There's a proposal.
Okay.
I can hear, but yes.
Well, I think it's also important for members to also take note that if your proposal, you put forward a proposal and something convincing is laid and you are convinced, you can withdraw rather than subjecting it to a vote.
I asked whether any other honorable member has any contrary proposal, and nobody said anything. Except for Honorable Williams.
What I'm saying is that the person who proposes can say, well, I'm convinced, so I'm withdrawing.
Okay, let's allow the Honorable Minister. Maybe his response can convince him to withdraw.
Jack is in his.
I think procedurally.
Thank you. I was even more concerned with something more substantial because, like Honorable Member for Serekunda says, I'm trying to even see the purpose of this full immunity, because in section 41, where the commission is established, 41(2)(b) says it can be sued and it can sue and be sued in its own name. So if you now go round to section 53 or clause 53, and you are saying it cannot be sued, and I do not know whether this can even stand the test in court, that you cannot sue civil or criminal against the commission, because the commission, I saw in other provisions where the commission itself can participate in proceedings on its own motion, or the commission can be asked, can send issues to court for interpretation. Like if somebody is requesting for an information and the commission rules that that information should be released and that particular authority may be in defiance, the commission can proceed to court. So if it can proceed to court, in what name is it going to go to court? And if it can sue naturally, then it should be able to be sued. So this immunity clause, I don't know what purpose it will serve. It's mutually contradictory, and I don't think it will even stand the test in court. So to say that the commission cannot be sued civilly is very sweeping, and I don't think that can constitutionally stand. Because it's an authority that will be involved in making decisions, it will be owning assets, it will be entering into contracts. So how do you expect that it will not be sued?
And in any event, Honorable Minister, as you rightly indicated, clause 41(2)(b), the commission is a body corporate with perpetual succession, capable of suing
and being sued.
Yes. That's taking them to
That's
court.
what I read.
It can take people to court. So now you come again and say criminal or civil proceedings shall not be brought against the commission. I think that's a clear contradiction. It's time to be corrected.
Maybe we'll flag it. I think probably the motive here is to give some form of protection maybe to the commissioners and the staff, but I don't think we achieved it properly with our wording. It's not intended to seal the commission itself from lawsuit. I think they're intending to seal the staff and commissioners from some form of lawsuit while they are serving, discharging their duties. And even there, we normally limit it to usually like the National Assembly, on your way to commission sittings and on your way back, you cannot be served. But you cannot seal even commissioners from complete civil litigation. And so on. And staff also, like some people are trying to point out, if the actions in good faith. But whether you add good faith or not, I agree with those who are saying that. Whether good faith is there or not, it will always remain the test. Whether you acted within or outside of your powers. So we will probably, my drafting team is with me here, we will look at that. we would want to achieve the motive, our objective here, that some form of protection need to be given to people serving in such institution. But we do not intend to seal the institution itself from being sued.
Well, in that regard, I'll just refer you to the National Human Rights Commission Act. Not that, as you rightly said, we're going to copy. But best practice. What it says here is immunity of the executive secretary and staff, other staff. I quote, the executive secretary and any other staff of the commission, not the commission, shall not be subject to civil or criminal proceedings or be personally liable for any act done or omitted to be done in the performance of his or her functions. So you can just think about it. We're coming back and we'll reflect on it, what is best practice.
Yeah.
Thank you. Yes. Yes. Can we just allow him to consult so that before we complete this exercise, they will get to do. But I think we can proceed. If there are no, we can proceed, yes. There are no contentious issues.
Yeah.
Clause, we were on 53 is flagged. So 54. Sorry, yes?
Well, I think 2 is relevant. A staff who discloses wrongdoing within the commission may not be subject to any punishment in the course of their employment by reason of the disclosure. I think this should stand. This is different from the first one, is it? Yeah. This should stand. Yes. I thought we are leaving 53 and come back to it.
Take a vote on, they're coming back. No, I'm talking about 53-2. Or we wait, okay, right. Thank you. Part 6, powers and duties of the commission. Clause 54, powers and duties.
Clause 54. Clause 54, powers and duties.
Thank you very much. It is proposed that clause 54, powers and duties, stand part of the bill. Those in favor, please say aye. Or before we do that, before he comes, any observations, proposals from honorable members, guided by the report? Before I allow the chair to guide us. Chair, can you guide us?
Yes, thank you. The committee doesn't have anything, any recommendation on this particular clause.
54.
Yeah.
Madam Chair, Honorable Chair.
Where is it coming from?
Yes, 50.
From where? You did not raise it. Good. Scale is.
Yes, 54.3. I think during the. Yes, I think during the discussion, I think we thought that may should be changed to shall. I noted it here. I don't know whether that suggestion or proposal still stands. The commission shall instead of may.
Can you put it down and write it?
Honorable Chair.
Yes.
Well, for me, I would rather suggest that this may remains, make it optional, that they may do this or they may not, rather than making it, binding on them. So I think it's necessary that we give them that latitude. They may not. May, I think, should stand, should stay.
Chair, What is your...
Actually, the member for Kiang is right. We highlighted it during the meeting, but at the end of the day, we settled for May to leave as is. Yeah, but he's right that it was highlighted during the meeting. Yeah.
Till the May. Before we take a vote, look at 4. Subclause 4, you have A, B, up to E. Any observations on the remaining clauses? No? Okay, thank you very much then. It is then proposed that,
The issue that was raised about may and shall, we are talking about power, isn't it? Yes, I said we're talking about the powers of the commission. So, well, it has power to do all these things. So, it's not about it must do it, but it has power to do so. So why the may? That it has power to do something. Yes. Yes, so even with 3, it has power to do so. It does not mean that it must do so.
it is proposed that clause 54, powers and duties of the commission, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 54 now stands part of the bill. Thank you. Next.
Clause 55, referral powers.
Thank you very much. It is proposed that clause 55, referral powers, stand part of the bill. Any observations, recommendations from honorable members? Chair?
The committee is okay with this particular clause as well.
Thank you very much then. In the absence of anything, we take a vote. It is proposed that clause 55, referral powers, stand part of the bill. Those in favor, please say aye. Are you guys hungry? Those in favor, please say aye. Aye. Those not in favor, please say no. The ayes have it. So clause 55, referral powers. Now, you see, we've already taken a vote on this. You just?
In 55, sorry, I'm just coming in from the bathroom. In 55, it says referrals to the High Court or the Supreme Court. So I was thinking that these are interpretation matters, so they should go to the Supreme Court rather than put High Court there. I'm just trying to seek for that.
I wish the honorable minister is here, but definitely there are certain, it's not everything that goes to the Supreme Court. Supreme Court is the apex. There are some minor applications that you take to this High Court. So I think look at our 55 referral powers. He's thinking that we should take everything to the Supreme Court, or everything should be taken to the Supreme Court and not the High Court.
Now the Supreme Court has an original jurisdiction. So there are certain things, it's not a court of first instance. So there are certain cases that cannot commence in the Supreme Court by its nature. They have to commence elsewhere and end up there. There are only few issues that can commence in the Supreme Court, and they have been identified. Thank you.
I think we're okay with that. We started the voting actually. It is proposed that clause 55, referral powers, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 55, referral powers now stand part of the bill. Thank you. Proceed.
Clause 56, general duties of the Commission.
Thank you. It is proposed that clause 56, general duties of the Commission, stand part of the bill. Any observations, proposals? Honorable members, 56? No? Chair?
No, we are okay with that.
Yeah, okay, as it is.
Yeah.
Okay. We then take a vote. It is proposed that clause 56, general duties of the Commission, now stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 56, general duties of the Commission, now stands part of the bill.
Clause 57, annual report to the National Assembly.
Thank you very much. It is proposed that clause 57, annual report to the National Assembly, stand part of the bill. Any, yes, Serakunda?
This should reflect section 175 of the Constitution. I'm just putting it right there.
So that we'll have it on the records, please. Thank you. Just the insertion of it in the relevant paragraph or sentence at the beginning. Any more honorable members whilst he's doing the amendment? Anything on 57? Okay. Please, can you help? Oh, yes, okay. Thank you.
Let me put, let me sign it.
Thank you. Please, I cannot figure out the handwriting, so one is saying that clause no, this was the earlier one, okay. This is by Honorable Woolley West, the earlier one where you delete the off. Okay, there is a proposal that this should be written 3 months of the end of its financial year. So, Honorable, can you just see where it should be inserted in the paragraph after where?
Yes. 57.
The Commission shall prepare and send to the National Assembly 3 months. 3 months at the end of each year. That's the proposal. That's the amendment. To be in line with all the other public enterprises. Or in quotes. Yes, it's a constitutional provision. Can you read out your proposal, Honorable Serakunda?
Yes. So that is the annual report to the National Assembly. The Commission shall prepare and send to the National Assembly within 3 months, the Commission shall, within 3 months of the end of its financial year, submit an annual report to the National Assembly. Yes. The Commission shall, within 3 months of the end of its financial year, submit an annual report to the National Assembly, and the rest will follow.
It is proposed that clause 57, stand part of the bill with amendments. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it, so clause 57 now stands part of the bill with amendments. Thank you. Can you?
Clause 58, promotion.
It is proposed that clause 58, promotion, stands part of the bill. Any observations from honorable members? Any? Then chair?
Yeah, we are okay with this particular clause
You're
as well.
okay. Serakunda, your mic is on. Can you? Thank you. So it is proposed that clause 58, promotion, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So now clause 58, promotion, now stands part of the bill. Can we proceed?
Clause 59, research and law.
Thank you very much. It is proposed that clause 59, research and law, stand part of the bill. Observations, proposals, chair?
No, we are okay with this clause as well.
Okay. It is proposed that clause 59, research and law, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 59, research and law, now stand part of the bill.
Clause 60, monitoring.
Thank you very much. It is proposed that clause 60, monitoring, stand part of the bill. Observations, honorable members, comments? Chair?
No, we are okay.
It is proposed that clause 60, monitoring, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 60, monitoring, now stand part of the bill.
Clause 61, implementation plan.
Thank you. It is proposed that clause 61, implementation plan, stand part of the bill. Observations, honorable members? Chair?
No, we are okay.
Okay. It is proposed that clause 61, implementation plan, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 61, implementation plan, now stand part of the bill.
Clause 62, publication of information manual.
Thank you very much. It is proposed that clause 62, publication of information manual, stand part of the bill. Observations, proposals by honorable members? Chair?
No, it's okay.
You are okay
fine.
with
Yeah.
it? It is proposed that clause 62, publication of information manual, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 62, publication of excuse me, information manual, now stand part of the bill.
Clause 63, annual reports to the Commission.
Thank you very much. It is proposed that clause 63, annual reports to the Commission, stand part of the bill. Any comments, observations from honorable members? Chair? 63.
It's okay also, yeah.
We are fine with it, okay. It is proposed that clause 63, annual reports to the Commission, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So, clause 63, annual reports to the Commission now stand part of the bill.
Clause 64, proactive disclosure reports to the Commission.
Thank you very much. It is proposed that clause 64, proactive disclosure reports to the Commission stand part of the bill. Comments, proposals, observations? Chair?
Yes, this one is also okay.
Thank you very much. It is proposed that clause 64, proactive disclosure reports to the Commission stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 64, proactive disclosure reports to the Commission now stands part of the bill.
Clause 65, auditing powers of the Commission.
Thank you very much. It is proposed that clause 65, auditing powers of the Commission stand part of the bill. Yes, Honorable Member for Serekunda. Please, can you, Honorable Member, read that section? Yes, I think there's a proposal, but can you read it out before you submit the written one?
Yes, I see here auditing powers of the Commission. And auditing is the power of the Auditor General. So I'm saying, why don't we use supervision powers of the Commission? Yeah, I'm recommending we put supervision powers instead of auditing powers.
There is a proposal, instead of auditing powers, supervision powers to be used instead of auditing. I don't know. Because
they are monitoring, as the member has rightly said, monitoring, they are monitoring compliance.
instead of supervision, you're now taking to monitoring.
Yes.
Yes,
Am I right?
Yeah. I'm
Monitoring instead of supervision.
Yes.
So that's the proposal. Do you have any comments on that?
Yes, I would rather go with monitoring because in general, auditing really refers to financial statements here. So I think monitoring will be in a better position.
So we amend the auditing powers to monitoring powers. Honorable Minister, do you have any comments on that? On 65, instead of auditing powers, monitoring.
There are different forms of auditing, not only financial.
Except for the general term, generally. I'm sure if you Google auditing, it will tell you. Proposal is saying the word auditing, monitoring.
Well,
Your observation.
the word audit is commonly used for financial inspections, but loosely it can be used on a generic term as well. It can be a systemic review or assessment of something. All right, so from that perspective, yes, but Honorable is speaking for the avoidance of doubt and so on, because commonly we talk about audit on financial inspections and analysis, but you can also use it as a general term which stands for a systemic review or assessment of something.
So,
Also came from Serekunda.
yeah, do they use social auditing then? Social auditing? Is there any element evolving as social audit? So if there is something developing as a generic word, social audit, then it's better to use social auditing powers.
Basically, in fact, what the section is saying is an inspection function. It's just to inspect institutions and see whether they're in compliance. So the function is inspection. They're using the word audit, but if you go inside, it says the powers of the commission to conduct audit. So the specific powers is to conduct inspections. So basically, it's an inspection function. So I think it's just a choice of word. So monitoring and inspection would suffice for what we want to achieve here.
Was to use the word monitoring. Chair, I saw you raise your hand.
Yeah, because I was referring to the model law on access to information for Africa, prepared by the African Commission on Human and People's Rights. And I think also they use the word monitoring here. So I think it's in place when we use the word monitoring here.
Can we put our phones on silence, please? Yes, Ilyasa.
Thank you, Madam Chair. If you go to 65/2003, D, or starting from C, monitor implementation of its recommendations, and D, investigate reason for non-compliance if incomplete, if. Have you seen it?
Is incomplete.
Yes.
Now we are looking at 65 together, but I also have one observation, one further observation.
What part of 65?
I don't have any objection with the use of the word. I support the use of the word monitoring, but let's also just look at the details of the section where the word audit is used. Wooly West, your mic is on. Yes. Wooly West,
Yes?
if your technical team, Honorable Minister, can also look at it, the powers of the Commission to conduct an audit. B, 65(2). Then you have 2B also, the word audit is used there. Then you also have E, wherever the word audit is used. So it will have to be uniform. So
I think safely we can replace the words audit with inspection.
inspection.
Yes.
Wherever the word audit appears.
Apparently, yes. Because like B, undertake investigations, it deems appropriate in furtherance of the inspection.
Of the inspection.
You can use that here.
Yes.
Yeah.
Yeah, I think it's better to just bring it in line. Chair? You have
Yeah, I think that's okay.
Yes. Thank you very much. So it is proposed that clause 65, auditing powers of the Commission. No? Pardon? Oh, yes, sorry. It's incomplete. Investigate reasons for non-compliance. We delete the if. Yes, the if should be deleted. Just write it for it to be, it will form part of the amendments. Can it come from you, please? Honorable Member for Ileasa. Yes, just take a piece of paper that under section 65, 3E, the word if to be deleted. So can we go ahead with the vote? Okay. It is proposed that section clause 65, auditing powers of the commission, stand part of the bill with amendments. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Clause 65, auditing powers of the commission, now stands part of the bill with amendments. Thank you.
Clause 66, effect of non-compliance.
Thank you. It is proposed that clause 66, effect of non-compliance, stand part of the bill. Any observations, honorable members? The chair? 66.
No, we don't have anything on that one.
You don't have anything? Yeah, it is proposed that clause 66, effect of non-compliance, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 66, effect of non-compliance, now stand part of the bill.
Clause 67, appeal to the commission.
We now come to part 8, appeal to the Information Commission. Please, sorry. Sorry, where were you?
66.
I'm sorry. Part 8, appeal to the Information Commission. It is proposed that clause 67, appeal to the commission, stand part of the bill. Any observations? Proposals, honorable members? No? Chair?
We are fine.
Yeah, okay with it, okay. Now it is proposed that clause 67, appeal to the commission, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 67, appeal to the commission, now stands part of the bill.
Clause 68, direct appeal.
Thank you very much. It is proposed that clause 68, direct appeal, stand part of the bill. Honorable members, observations, proposals? Chair?
No, it's okay.
Yeah, okay. It is proposed that clause 68, direct appeal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 68, direct appeal, now stands part of the bill.
Clause 69, notice of intention to investigate or hear a matter.
Thank you very much. It is proposed that clause 69, notice of intention to investigate or hear a matter, stand part of the bill. Observations, proposals, or chair?
No, we are okay with it.
Sorry, pardon?
We are okay.
Good. It is proposed that clause 69, notice of intention to investigate or hear a matter, stand part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 69, notice of intention to investigate or hear a matter, now stands part of the bill.
Clause 70, notice to third parties.
Thank you very much. It is proposed that clause 70, notice to third parties stand part of the bill. Honorable members? No? Chair?
We are okay with this clause as
We are
well.
also okay with that. Thank you very much. It is proposed that clause 70, notice to third parties stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 70, notice to third parties now stands part of the bill.
Clause 71, right to make representation.
Thank you very much. It is proposed that clause 71, right to make representation, stand part of the bill. Observations, honorable members? Chair?
No, we are okay.
You can, okay. It is proposed that clause 71, right to make representation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 71, right to make representation now stands part of the bill.
Clause 72, notices and communication.
Thank you very much. It is proposed that clause 72, notices and communication, stand part of the bill. Honorable members, your input? None? Chair?
That's also okay.
Yeah, okay. It is proposed that clause 72, notices and communication, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 72, notices and communications now stand part of the bill.
Clause 73, orders, decisions, and directives.
Thank you very much. It is proposed that clause 73, orders, decisions, and directives stand part of the bill. Any observations? Yes, Woolley is?
Yes, thank you. I was looking at 73E, where it says imposition of a fine not exceeding $10,000 in cases of a failure by an information holder to comply with an obligation under the Act. I think 10,000 is small, because if you want to do the work, what will it entail? It will be more than 10,000, far more than 10,000. So I can fail to carry out any obligation, and when they find me 10,000, I just pay 10,000. So we need to look at that. 10,000 these days, the inflation is nothing. 10,000 is too much. 10,000 is enough.
There's a proposal.
It's too much. I said 10,000 is even too much. This man is rich. 10,000 is okay.
Very rich, I think. Yes, Musumbala.
Thank you. Chair, I have a question. Is it the institution or the head of the institution who is going to be fined here? Then the issue of the 10,000 can come into question. Can the minister help? Who is going to be fined? Because it says information holder. So is the fine going to be directed to the institution or the managing director or the head of the institution who refuse in one way or the other to give the information?
The holder.
Okay, Honorable Chair, just to help my colleague, I think the fine will be borne by the
No more observations. Okay, Chair. Well, you see.
Well, it's the information holder. I'm sure that it is defined in the interpretation. It means
Interpretation
information
section,
holder
I see.
means a public body.
Information holder means a public body. That's his interpretation. So, that takes care of it. That takes care of it. Good. 70, okay. Yes, sorry, Chair.
Yes, perhaps we will need some clarification from the minister on the same issue. Because he's saying imposition of a fine not exceeding $10,000 or in cases of failure by an information officer to comply with an obligation under this act. But then if you go further to the offenses, which we will reach in 76, is imposing a fine of like $100,000. So maybe the minister can help us understand really the difference between the two. Here, you are not complying with an obligation under this act. Wouldn't that actually tantamount to an offense itself? And then you are imposing 10,000, but then when you go to the offenses, you are talking about 100,000. That is 76 on page 51, the top part of page 51. The top portion of page 51 is talking about the offenses, committed offense and liable to a conviction or a fine of $100,000. So I'm just trying to see, when they fail to comply with the act itself, is that not an offense itself? Now, if you're going to charge 10,000, and then on the other part where you have the offenses, you're going to charge 100,000, wouldn't that create some kind of ambiguity or some sort?
This is another area that would require a closer review, because this is a quasi-judicial function being given to the commission here, and it means it will be the sole determinant of the guilty party, and there are issues, constitutional issues connected to that before you impose such punitive measures on people, right of to be heard and things like that. So I was thinking we could better improve on this if the commission is of the view that somebody is not in compliance with their directives. Without any genuine excuse, the person could be cited for contempt, and this will be a basis for the person to be taken to court, and then the court will hear and determine whether the person is guilty of contempt, and the person could be punished accordingly if he is found to be guilty of contempt to the commission, then giving the power to the commission to punish without the person giving the opportunity of free trial, of being heard and the matter being determined. Because to impose a fine is a quasi-judicial function. And normally there are standard procedures before you impose a fine or jail term somebody. The person should be entitled to be heard properly. And that can only take place in a court of law. So I think people can be cited for being in contempt of the commission, and then that is an offense that can be triable in a court of law, and if you are found to be liable, then the court will punish you appropriately. So if they give a directive, of course they need a biting teeth. I agree. But that could be, if you disobey them, you are in contempt. Just like the National Assembly itself. People can be in contempt, but the National Assembly does not impose a fine on somebody who, for example, deliberately refused to come and answer to your invitation. But then the person can be cited of contempt and be taken to court, and when the court agrees that the person is in contempt of the House, the person will be appropriately punished by a court of law. So, to me, this is a function of a court, of a judicial body, to impose a fine. Is subject to debate, but if you agree, we can redraft that and make people who are disobedient to directives, lawful directives of the commission, to just be liable for contempt.
It's better to do the right thing. Maybe again, you can equally flag it, and maybe we can come and could quickly redraft that before we go on break. Thank you.
So,
Is and then-
do we have to put a penalty in the penalty clause, or we just leave it to what contempt means in court? Like, for example, they can always take you for contempt, and the penalty for contempt is already in another law, right?
You can put the punishment for contempt under this law in the general punishment section, that anybody found liable of contempt on any of the proceedings in provisions of this act will be liable, upon being found liable, will be liable to be punished ABC. Like this 10,000 could be repeated in the punishment section, that if you are found liable of contempt. Yes, we can redraft it. We have already redrafted section 52 or clause 52 and 3 earlier, the ones that we were debating. So we can quickly redraft this one as well. But that is if you think our proposal is acceptable.
Yes, I agree with the minister's proposal, and I think, we should be careful. Some of these clauses are related. So if we are going to mention specifically, about $10,000 a year, and it falls under the penalties, which is saying $100,000 is, there could be conflicting of what amount to pay.
Sekunda.
Yes, the Honorable Minister is perfectly right. We cannot talk about access to information bill and start creating administrative courts, which is the beginning of any form of abuse and excess. So E does not belong there at all. I think it's orders, decisions, and directives it can make. So if it is orders, decisions, and directives, it cannot be orders that belongs to the judiciary. So they can give orders that do something, failing which that may constitute an offense. So, and after an offense, then there is penalty. So there should nothing should reflect here on the 73 that deals with penalty. It is the powers that they have to give orders, decisions, and directives. And I agree that they should redraft that and then take penalty where it should be after an offense.
Thank you. That means E can be deleted for now, completely.
Yes,
with that submission,
it
yes.
should be, yeah.
I agree.
Proposal is to delete E, pending. You will bring something else. Creating section here, yeah. 76 is the offenses.
Yeah, Chair. Just to reaffirm what the minister was saying earlier, in fact, if you continue on G, it's telling you imposing a contempt order. So essentially, they can be charged for contempt for not really fulfilling that obligation here.
Do we then suspend 73, even though E is deleted?
No, it's okay. It can be
It's okay. We can delete. We are okay with it. Then you will bring it. Thank you. To the other offense-creating section.
So the numbering
Changes. No, instead of F, it will be E. You've got that? That is under 73. So can we proceed? Thank you. It is proposed that clause 73, orders, decisions, and directives stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 73, orders, decisions, and directives now stand part of the bill as amended. Thank you.
Clause 74, content of recommendations, findings, orders, decisions, and directives.
Thank you very much. It is proposed that clause 74, content of recommendations, findings, orders, decisions, and directives stand part of the bill. Honorable members, do you have any observations? Yes, Woolley is?
only observation is on the caption, where it says recommendations, findings. Is it, I think we'll have a comma after recommendations, and then findings and orders. Right?
No, that's okay.
That's okay.
Yes, the comma needs to be there
The comma,
between
yes.
recommendations and findings, yeah.
Okay. So it is proposed that clause 74, content of recommendations, findings, orders, decisions, and directives stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 74, content of recommendations, findings, orders, decisions, and directives now stand part of the bill as amended. Proceed.
Clause 75, third-party information release is in public domain.
Well, clause 75, third-party information released is in public domain. That is what is on the bill. So, any observations? Yes, Woolley is.
The fine where it is, or we should take it to the penalty clause? Should we take this fine, the fine of $100,000 or imprisonment in this place, or we should take it to the penalty clause?
We are on third-party information first. Can an honorable member please look at the title, which says third-party information released is in public domain. Can we have assistance on that? I stand to be corrected, but something appears to be wrong here. Can you read it out all and see? Yes?
Yes, I think the heading is a little bit clumsy, and I would rather use the one that is in the model law, where it says information released is in the public domain. Information released is in the public domain. Yeah?
Can I say something? Can I make a suggestion? Yes. We can simply say third-party information released in public domain. Just take the is out. Is out. Third-party information released in the public domain. Take is out.
Read third-party information released in the public domain.
That's right.
In the public domain.
You can say in public domain, but
so we remove the is. So can we just have a note on that? The is on the clause 75 to be deleted for the records. Yes, just a short note. Chair, apart from that?
Yes, I think we can change the heading to read that.
Okay. So it is proposed that clause 75, third-party information released is in public domain, stand part of the bill as amended. As amended. We are reading what is in the bill. So, those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 75, third-party information released is in public domain, stand part of the bill as amended.
Clause 76, offenses.
Thank you very much. it is proposed that clause 76 offenses stand part of the bill. But we have a proposal from the Honorable Member for Ileasa that he is proposing clause 76 offenses, subsection F, to be reduced from, or the fine to be reduced from $100,000 to $50,000. That is F. Is it F? Actually, it's not F, but it's the last paragraph. Do you have any other proposal on the 76? That's the proposal for the fine to be reduced from 100,000 to 50,000. Honorable members, any observations, suggestions? Yes, Upper Fuladu.
Yes, thank you, Madam Chair. I made a similar proposal, but instead of reducing the fine, I am suggesting to maintain the $100,000 and increase the 6 months imprisonment now to 1 year, because that was the original bill. That was what was captured in the original bill. And the reason being is denying people of their fundamental rights to information is a big offense. And access to information can be, for some people, could be a life and death matter, or right to their freedoms. So denying such should not be penalized leniently. I think 1 year, as was captured in the original bill, should suffice.
Honorable Member, I'm sorry, it wasn't brought to my attention. He has sent in a proposal that 76F to read, directs, proposes, counsels, or cause any person in any manner to do any of the above, commits an offense and is liable on conviction to a fine of $100,000 or imprisonment for 1 year or both. That is his proposal, and Ileasa is proposing $50,000 instead of the $100,000. Can we have views first before you come? Yes, Opanyomi.
Thank you very much, Honorable Chair. I think the amount stipulated in the bill is okay. $100,000 with 6 months imprisonment. I think that's fine. That's my proposal.
Yes, the amount stipulated in the bill is okay with me. But then, like he said, Honorable Jawara said, I think the 6 months has to be at least adjusted so that, we will not create that room for people to just sit down and say, okay, they want to deny people to have access to information. At least with 1 year, that will at least send a very strong signal to them.
My view is that the clause should be left as it is. You should not increase the number of months to 1 year. Because, there are two things that have been meted on the person concerned. $100,000 and at the same time imprisonment of 6 months. That's quite ridiculous. I agree that the offenses are grave. I don't agree with the reduction of the sum, but I don't agree with also the increment of the imprisonment. 6 months fine, 100,000 fine.
I need to be clear on this. I have 100,000 or 1 year or both. And the other one is 50,000. So, is there a third proposal?
Yes, I second the 50,000
The second, the 50,000.
And then at the same time, to remove both.
To remove
So
both.
that is
It's
all.
either or.
It's either or. You see, custodial sentence means that you have to send people to prison and you have to feed them. We are talking about decongesting prisons, and then we should be thinking of alternative to imprisonment. So we should really move away from custodial sentences.
Now we have two proposals. So I think we'll have to, Chair.
Thank you very much, Honorable Chair. I think the committee actually has a contrary view. The committee believes that the amount should be increased to 250,000, and the imprisonment should be increased also from 6 months to 2 years imprisonment, because of the importance of this aspect of information. You know, you are dealing with something very crucial, and especially in this day and age, where you have this terrorist financing, anti-money laundering, etc., etc. That is in billions, for example. Now, if you ask for information and somebody refuses to give it to you, and this is crucial in the decision somebody's going to make, I think we really need to put some punitive damages that will be deterrent. So it's not really about the money that the government is going to take, but it's about deterrent. We want to deter people from, not giving the correct information to the requesters. So really, the committee requests that we increase the amount so that it can serve as a deterrent for people to give the right information.
No, I have two ways. I want to support the provision as it is in the Act. The 100,000 and 6 months.
Yes, thank you. For me, I'm thinking about, you see, the whole object of this bill is to ensure that people get access to information. So if people seek for information and then you can see people obstructing them to deny them that information, then that's the whole use of this bill. What will be the use of the bill? So I feel that the deterrent should not be an easy one, because if it is easy, it's easy for me to deny somebody and just pay 50,000. So I propose that like the oil is there, but then the imprisonment, should not be small, because if it is small, they will just pay. Some will want to just pay and then, or not pay and go to prison for 3 months, 4 months, that type of thing. So it should not be an easy thing, like the chairperson has said. This is very important.
Thank you very much, Honorable Chair. I think yes, of course, it's deterrent. We want to deter those that are preventing others to have access to information. That's fine. But we may also be talking about offenders who are in a position that they might not be able to pay if the fine is high, too high. I would rather support the fine to be reduced. And of course, this or element, not both, but this or element, either you pay a fine or you go for 6 months imprisonment. I think 6 months is sufficient. What the Honorable Chair of the Information Committee is saying, of course, it can be incremental. This can come. If we go along the line and found out that, big time crime is really, taking advantage of this, you can always resort to National Assembly, you can always come back to National Assembly. But for a start, let's just start small and then see how it pans out.
Madam Chair, I support the position of the committee. It's not the ordinary people who do this. These offenses are grave. And it is not a poor and ordinary person who does this. So, in fact, what he says, I support 100%, 250,000 and 2 years imprisonment. It's just a minor correction, it's language. Clause 76(1)(e). Madam Chair, are you following? You are not listening to me. Okay, now I agree. Now I say clause 76(1)(e). You say it says interferes or obstructs the work. You don't say interfere work, you say interfere with. Interfere with or obstructs work. So you should add with after interfere with. You want me to write it? You are looking at me as if you are angry. Are you angry?
No, I'm just thinking fast that maybe the contention is between, now we have a third option from the committee. I don't know whether it is on their reports.
Option.
Or there's the first option,
Yes.
200,000, 250,000, and 2 years. Then we have.
But that's not even written.
Sorry, no, Honorable, please. We have the 200, it is in the report that was adopted. The report, okay. Now, there are counter proposals. Now you have 100,000, 1 year, or both. He is proposing 50,000. I think Serakunda is saying we delete the imprisonment term.
Yes, we have 50,000 and 6 months, and both, we remove both.
And remove
It's
where?
all,
Either or. So I think the Honorable Minister wants to come in and shed light on one or two issues.
Thank you. I am recollecting my days as a sitting magistrate. It's easy to put these punitive measures for here, at least for you, but it's very difficult to sit there as a court to impose a jail term after having found somebody guilty. It's difficult to send somebody to prison for a certain number of years is a problem, but I don't intend to dampen your spirit of imposing punishment. However, I think there could be a middle path. I think usually it's better when we make punishments and give the courts a range within which they exercise their discretion. You can have a minimum and maximum and leave the court in between. And the court, because the court is the one that is looking at the perpetrator, studying the demeanor of the perpetrator, and will put into consideration whether the person has regretted, is remorseful or not, and then can determine what is appropriate at that moment. Whether it needs to be very high, it has to be midway, or it has to be less, depending on what transpired in court during the trial. So it's convenient to say, if you say 100,000, you are not giving the court any latitude to go below 100,000. That means that becomes the minimum punishment. So even if somebody, actually this is a specific intent crime, somebody, whoever is found liable under this offense, the person would have intended it. Notwithstanding, having intended it and committed the crime, the person may regret it completely, even during trial, and would never do it again. If the court is convinced of the remorsefulness of the victim or the perpetrator, the court may be minded to be lenient in the punishment. Of course, the criminal conviction will be there, but the punishment can be lenient to give the person a second chance. So if you put the punishment in such a way that the court would not have any discretion, whether you say 100,000, 50,000, or 1 million, it means anybody found liable will be facing that penalty the court cannot do anything below that. So for me, I would propose a middle way. You have a minimum to cater for all of you. Those who think it should go very high, you can still maintain your 250,000, but accommodate the ones that believe in 50,000 also. So you can say a fine of between 50,000 and 250,000. So that whoever is found liable, then the court will now consider what I have said. If somebody should be punished for 50,000, depending on the gravity, the person goes with the 50,000 fine. So those who believe in leniency would be accommodated, and depending on the gravity of the kind of offense too, the court may decide to go high-handed. But I think a range approach is better, and I agree with member for Serekunda. If you say, oh, both, if the court woke up from the wrong side of the bed, it can convict you, fine you, and still impose the custodial sentence at the same time. So you will still pay the fine and still go to jail. So if this is what you intend, then the or both will be okay. But if you think you pay the fine, you are sufficiently punished, you can go home, or if you cannot pay the fine, then you serve the jail term, either or. But do you intend people to pay the fine and still go to jail? If that's what you intend, the or both will becomes relevant. But if your mind is you are punishing either or situation, pay fine, go home. If you cannot pay fine, go to jail. But otherwise, the court can be minded to impose the maximum fine and the maximum jail term also at the same time.
Here of Fuladu.
Yes, I agree with the minister to have that bracket between 50 and 250,000. As you said, the court will determine the gravity of the case. However, I think to apply that same principle, I think the court should also have discretion to decide whether both the penalty, the financial penalty, is in the necessary and a jail term. We have to be mindful that some of these cases that we're talking about can be very severe, denying people their fundamental right to freedom of access to access of information, which could see those people being sent to prison themselves. So anybody who is determined to actually deny those people that information is deliberately violating the law and should be punished accordingly. So I think the court now have that room to decide, given the gravity of the individual cases. So I agree with the minister, but it should be both, or both. Both, like you said, you should read, between $50,000 to $250,000, or imprisonment for what we agree, 2 years, or both.
So the imprisonment could be between 6 months
and 2 years,
and 2 years as well. So both of them have to be in range.
Yeah, thank you.
I still take it that there's a proposal to delete the alternative, that you cannot have both.
Then I propose, Honorable Chair, because we were talking about 10,000 that we lifted from 73, which they're going to redraft and include in the offenses and the penalties. So we can say between 10,000, a fine of between 10,000 to 100,000, or imprisonment for not more than 6 months, for a term not exceeding 6 months.
For Serekunda is that in view of the fact that we had earlier on deleted the 10,000 fine, he is now proposing a fine of between $10,000 to replace that fine to 100,000, 10,000 to 100,000, or imprisonment for a jail term of not exceeding 6 months. That is your proposal. Chair of the committee.
Thank you very much, Honorable Chair. I think the recommendations from the committee, we looked at it in several ways. Now, can you imagine a requester for information from the Accountant General of the government of the Gambia, who decides to willfully give misleading information to an individual, and you're going to in turn and then fine the Accountant General of the Gambia $10,000 for giving misleading information? Or better still, you look at the Director General of the National Council for Arts and Culture, who has a lot of information about this country, and he willfully gives misleading information to individuals. I think these are grave, and that's the reason why the committee looks at it very carefully, and as a form of deterrent, to put in a financial fine and at the same time for imprisonment, so that they can deter people from giving misleading or falsified information, or at best to destroy information. For example, another one is like with the Central Bank of the Gambia, who holds a lot of financial information about the government of the Gambia. If they willfully destroy information, Honorable Chair, I think for me they should be punished in the hardest way possible to prevent somebody else from doing it again.
Sorry, let me clarify something quickly here. Some of the offenses here are already offenses in the penal code and other laws, right? So if those laws, if somebody is suspected of committing a crime here, for example, you are calling it here as destruction of information, but that could also constitute destruction of evidence in another law, all right? If that law is more serious, probably the prosecutors will choose to charge you under the most serious law. Here, the objective is you must not stand in the way of providing information to the information seekers. We also need to bear in mind the custodians of this information generally are public servants, okay? If they are charged under these offense sections and they are convicted, even if you deem these punishments to be light, but by virtue of their conviction, they will lose their job, because it's a criminal conviction. So they will lose their job automatically. So for some of them, depending on their status in their organization, the fact of carrying a criminal conviction on your record and losing your job, that even is more serious than the fine that they are going to be facing under this clause. So they have a double-pronged punishment they will be facing. So don't only think that the punishment is only going to be what we are seeing here. Because they are public officers. Once they are charged criminally and convicted, they lose their job. So putting that together, now reading all of that together, I don't think this is lenient. It's not lenient at all, because you may lose your whole life career by virtue of being convicted under here.
Thank you very much, Honorable Speaker. In fact, going by, this is exactly what I wanted to say, going by what the chair said, I think it convinces me that definitely we have to reduce the fines and the custodial sentence, and then make it both an option, because conviction itself is a punishment. So I think we should not be seen as conviction hungry, punishment hungry. In as much as we want to deter them from preventing information to be accessed, I think the punishment is sufficient. 6 months is sufficient as a custodial sentence, and $100,000 is, and not anything not exceeding $100,000 is also sufficient. I support that position.
Madam Chair, I am confused here. I want assistance. One, I asked this question, who is the information holder? And from the definition is the public body. Now, the punishment is talking about fine and jail term. If I am the head of the institutions and an information is sought from me I didn't give, the information holder is fine liable, and according to the definition is the institution. So come to the punishment now. If the court decide to jail, who is to be jailed? I want clarity here from the definition. Two, to me, we are trying to deter people not giving information. So in this essence, we are giving more power and more leeway for information seekers to get what they want. But are we also safeguarding the information holders? Probably, somebody might need an information from me, but from my own assessment, the information is also detrimental to national security. So what safeguard mechanism are we giving to the information holders also? All right? So these are the two that I want to be clear. If it is the information holder is the public institution, so and then the court decides to jail, who is going to serve the prisoner? Thank you.
Can I say something?
Yes, thank you. Quickly. Honorable member, the failure to provide the information requested by an information holder is a separate issue. This is offenses, and the list of offenses are listed here. These offenses most likely may be committed by public officers, but could also be committed by people who are not public officials. But these are personal liabilities. Even if you are the head of the agency, you destroy information that is being sought, or you damage it, or you alter the information. Remember, the offense is saying you have the intention to deny the right to access. That's the main key word here. A person who with intent to deny right of access. So you must specifically intend to deny right of access. And to put that intention into action, you resort to destroying, damaging, or altering information, or concealing information, or falsifying or making false records, or obstructing the performance of the information holder, or you interfere or obstruct the work of the commission, or you direct it, or you counsel somebody to carry out the above, but with the intention to deny access. So that is the baseline. You intend to deny access, and to materialize your intention, you either destroy, you conceal, or you obstruct, all to furtherance of your intention to deny access. Of course, even if you are a public officer, you don't need any protection if you do that. You have to face the full force of the law. Because you are not supposed to intend to deny access if the request is reasonable. The area that you ended up is, if as a holder of this public information, you believe that there is a genuine reason why this information must not be released, there are avenues for that. There are avenues for that. You can refuse to disclose the information based on national security, public interest, and all other issues listed therein. But then that will be scrutinized. And there is a due process for that. In fact, the commission will interrogate your excuse and either agree or disagree with you. And even if the commission disagreed with you, the commission is not the last resort. You can even go to court. So the public officers can go to court, and the Supreme Court, these are some of the special instances where the Supreme Court have original jurisdiction, and depending on what is your excuse, the Supreme Court will then have to determine whether genuinely there is a national interest to be protected. Therefore, the court will agree with you not to disclose the information, or your excuse is not genuine enough, then the court can order for the information to be released. So the request is one thing, the granting of the request is not automatic. It's not automatic. So public officers still can have reasonable grounds to deny the grant of information, and they will be protected by law. But the one we are looking at here is when you have a motive that is not legal. Because if you have a legal motive not to give information, you are covered by law. I think I just want you to, it looks like you are not at rest, but you should be at ease. I'm assuring you that any public officer that have a genuine public interest for not disclosing information, that is protected by law, right? But if you are not covered under that, you intentionally deny access to information, and by that intention you do any of the acts listed here, you will be committing an offense, and you don't need any protection of the law.
Yes, he said we list. Yes, Chair, I think we should definitely look at this thing very carefully, because the penalties, for example, if you look at A, destroys, damages, or alters information. Even if the person eventually goes to court, the person may not get back the information since it is damaged, it is destroyed. So I think that's the greatest one. So I think to say from this amount to this amount, and then this number of years to this number of years, to make it so that whatever happens here, the court decides the gravity of the, I think that will be much fairer. So whether it's from 50,000 upwards or it's from 10,000 upwards, it should take that trend, I believe.
I think the
yeah.
Honorable Minister made range,
the range,
find and
I'm supporting the...
You are supporting.
Yes.
Yes, Honorable Chair, you see, this is just information. Once you are seen to have committed a crime, you know, the charges can continue to increase based on the gravity of the crime, because it's not only a crime under the Access to Information Act, but it may go into other areas, and then you end up having charges. Barrage of charges. So here our focus is just the issue of information. And it's a democratic instrument. It's not a fascist instrument. You are teaching people to respect fundamental rights of people to gain access to information. So by having this penalty, it's a lesson that you cannot do that. And I don't see why we believe we have to make it excessive before the lesson is learned. I don't think that is really how you teach people in a democracy. I believe that it is to show that you cannot show impunity. Before there is impunity, nothing happens. You do something and nothing happens. Now we are saying, no, it's no longer impunity. If you do something, this will happen. And that's the lesson. I don't know why the excessiveness seems to be the issue. It's not the excessive, but the fact that now you have a penalty with fining or even imprisonment if it is seen to be an act that is intolerable. I believe that we deserve to treat our people that way.
Yes, two things is on the table here. The issue of this fine issues is on the table, and I also brought this, my confusion for me to be cleared. I want to talk about that. The ministers, my worry is information holder is the institution, but the definition column also went to define information officer. But in this, a person is mentioned. So I want the connection here. This person is talking about a private individual who has an information and is seek to give and refuse? Or is it the same as the information officer of the institution?
That's why I said the person could be any person. Okay, depending on which of the clauses, A, B, C, D, because there are different set of offenses created by each paragraph. So if you say a person who with intent destroys, damages, or alters information, this could be anybody. Right? For example, if there is a public record in my office and there is a request for that information by somebody, now, either myself or somebody who is affected by information could procure me as custody of the information to destroy or damage, but could procure a third party, a normal person in the street, to break into my office and probably steal that information or destroy it. So it could be a public officer, it could be a private citizen, but anybody who destroys or damages or alters information will be cut off here. So don't bother yourself as to who that person can be. It could be anybody. So depending on where, concealment, of course, most of the time that will be the person holding the information, because you cannot conceal something that you don't have. So that is more likely to be the people in custody of the information. Falsification too will be usually the people that are in custody of the information. So I said, you look at each offense. Some of them, they're more likely they are going to be committed by the public officials in custody of the information, but some of them can be committed by even private citizens.
see, there are two technicalities in this. There is a language technicality and there is a legal technicality. The first that the honorable member for Busumbala talked about is a legal person. That's the institution. That's not the one that we are dealing with here. This is both a legal person and a biological person. They are saying a person, a human being, not an institution, who can be either an employee of the institution or an outsider. That's what he's saying here. So, for me, this issue of being lenient and not lenient, this is somebody who is deliberately doing something. You don't have to teach that person anything. That person has chosen to do what he or she is doing. That's what the law is talking about, the proposed law is talking about. So for me, that person requires to be punished because he or she has chosen to do what is in his interest and not in the interest of society. So to serve as a deterrent, it has to be, if you are fighting somebody, you want somebody to be afraid of you, you must hit him or her very hard. And that person, each time he or she sees you, will be afraid of you. But if you do it leniently, you say, this man is cheap. And you know, money is the easiest thing in the world today. If you find me 1 million, even if I don't have a booty, my people have. I have friends, I have people who like Syria. They'll contribute, they'll not see Syria in prison, they'll pay millions and it will go. So this 250,000 is nothing. And therefore it should be added that this person must also go to jail. In addition to the 50,000. Now, look here. You know that what we went through for the last 22 years?
Thank you, thank you.
Total denial of this.
I don't know. Thank you very much. For me, I think now, I think we can narrow the issues, really, with the assistance of the Honorable Minister. I think we can narrow the issues to the penalties. I think we can narrow the issues now to the penalties. The range, let's agree on a range, and then we move forward. Otherwise, yes, let's agree on a range. So what, Honorable Busumbala, please again, can you? No, I'm coming. You've made your proposal. Thank you very much, Honorable Member for Serekunda. In fact, next time I'll bring his chair next to you so that. Now, the committee, they've already proposed 250,000 fine and the term and 2 years. Let's say, for instance, no, just so that we can have the figures, 250,000. The minimum was 10. No, but that's why you're giving the courts a range for them to maneuver, is it? I mean, he's given us his experience as a magistrate. But you want to tie, he says, if you tie the hands of the courts. No, I'm coming, if you tie the hands of the courts, but if you give them a range, depending on the demeanor and whether the offender has shown any remorse and all whatnot, and again, a conviction, a mere conviction, if without even going to jail, is something, you know.
Refine our proposal.
Yes. So that's what you have a proposal, a counter one.
This one.
Yes, we are with the chair. We are with the committee.
We are adding something there.
What do you want to add there?
I want to propose, Honorable Chair, the fine will be from $100,000 to $250,000. all the offenses there. And imprisonment, a term from 6 months to 1 year. No, I'm also being lenient, from 2 years to 1 year.
No, from my experience, I would rather if I have to pay $1 million than spend even 2 days in jail. Oh yes.
You hear that? Yes, Chair, you know, for me, I see these offenses graver than each other. For example, the first one, let me give you a scenario, very short scenario. You know, this is an orphan now. The father has passed away, but left all the documents, his compound documents, in the hands of an uncle who is refusing to provide these documents, or has destroyed the documents because he's refusing to give it to this orphan girl. So this is 5 compounds or 3 compounds, and then we're refusing to give the documents. Should you find that person 10,000? For me, that is my problem. I feel that is too deliberate. 10,000 is too small, because you are sitting on an information worth millions. So I would say the starting will be from 100,000 for the highest, and these other ones can start from. They should not all start from one place.
So your proposal is from 100,000?
Yes, from 100,000 for the destroying, damaging, and altering information. Yes, yes.
I can still help a little bit. Because the offenses themselves are in a range from offenses that may be very minimal to grave offenses like you said, I think the punishment can take the same pattern. For example, somebody who conceals, notwithstanding the concealment, the information was found anyway. That could not be punished, I agree, in the same way with somebody who completely destroyed the information beyond recognition. So the offenses themselves are in a range. So the punishment should be, the court should be given a range also, so that not everybody is punished irrespective of which of these offenses you commit. Because some of the offenses are destruction, some are damages, some are alteration, some are mere concealment. Irrespective of your concealment, sometimes the information may be found. So the gravity has gone down because you intended to deny somebody access, but inevitably the person have got access anyway. So I think the range thing can come low to accommodate those who will who may commit the same offense, but the gravity is very minimal, and those who may commit the same offense but with a higher gravity. I don't want to propose, I am not a member. But
yeah, thank you. Honorable Speaker, I think I'm fine with the range, but we also need to guide the judge in terms of sentencing guidelines. Now, you know, somebody who has destroyed, really, I can understand, however lenient a judge may be, you know, they may not sentence you on the high side, however lenient you may be. But, yeah, destruction, I'm saying. So, however lenient a judge may be, they may not find you on the low side. But for me, what I'm saying is, you know, there are various degrees of offenses. But I'm really very particular about willful destruction. I'm very particular about that one. That one must go to jail. That's what I'm saying. That person who willfully destroys information, that is meant for public interest. For me, I think that person must go to jail. The rest, we can have a range of fines, whatever it is. But okay, now what I would recommend now is the range of, I'll go with a Jatra from 100,000 finance it to 250,000. No. Let's go 100 to 250,000. Then, and jail term of 6 months to 2 years if the offense is willful destruction of information. So that one, very particular about that particular portion. The rest can be,
Honorable Speaker, I might be coming a little bit more frequent just to direct the debate. Honorable Salah have said, and I mentioned earlier, the willful destruction of the record. We are punishing here the intention to deny access to information. But destruction of public records is an offense of its own, punishable elsewhere in another law. So the person will not escape that. So you cannot cater for that here. Our focus here, like Honorable Foserekunda said, is only to punish the intention of denying somebody access to public information. Once you form that intention, because intention by itself is not, you cannot punish it, so that intention is provable by the overt act that you committed. So that's why these acts are listed as example of a manifestation of your intention. But the key word here, you only intended to deny somebody who lawfully requested for public information, and you were not willing to give that person that public information, and you did any of these things to deny that person information. But in addition to that, your conduct may be liable for other criminal offenses for which you will not escape, because public records are not meant to be destroyed, whether they are requested or not requested.
Let me read now the amended version so that we can adopt it. And it says, commits an offense and is liable on conviction to a fine from $10,000 to $250,000 or imprisonment from 6 months to 2 years or both. So that's basically what we are suggesting. No, leave it to the judge or the magistrate to decide that, whether he wants to give both or not. But that is what the minister is asking, and I think that is what the committee is suggesting.
Let me clarify something. I never said you put the boat there. I proposed the range, but the boat is a proposal from Serekunda to be removed. I did not express an opinion on it. I only explained the implication that if it is there, that means the court reserved the right of imposing the fine and the custodial sentence simultaneously. And when that is imposed, there is a default clause attached to a fine, which does never in our laws run concurrent with the custodial sentence. So you will serve them consecutively. Let me put that into context. If you are fined here for 100,000 or in default 1 year, and then you are sent to custodial jail term of 6 months, if you don't pay the fine, you will have to go for 1 year, 6 months. They have to run consecutive in our laws. They don't run concurrent. You will serve the custodial, and the defaulting jail term that is attached to the fine will come after, not along with it. So that's what it means. Like I said, I'm not a member. My role here is to help, explain, and the decision ultimately is yours. I remember one law that we usually cite in many times we try to guide, and I think some of our induction sessions that I attended, we've discussed this. Like the Drug Control Act is one act that at the time it was legislated, the intention, the parliamentary intent, it was so focused on fighting the menace of drugs. But the law is made so rigid and so firm that the prison is filled up. Because quite often once you convict, the court's hands are tied. And having sat in a court and have left as a principal magistrate, there are times that you can convict somebody. If you were not told by parliament what to do, your discretion could have informed you to do something different. So at sometimes it's good to give a little bit of latitude to the court. It always helps. I know, like you said, Chairman, you just need to trust the court. Unless a court is compromised, if the court is convinced that this crime is committed with a motive that is detrimental to the public interest, the court will punish appropriately. So you don't necessarily even need to tell the court what to do. Once you tell the court you can punish somebody between 10,000 and 250,000, trust me, a competent court will know when to impose the 250,000 or when to impose the 10,000. You don't necessarily need to guide them because they knew that you gave them that range and they have to exercise their discretion after conviction, and they look at a lot of things in exercising that discretion, and we are trained on sentencing guidelines. We know when you are given a range, when you go lower, middle, or go higher. They are professionally trained on that.
Yes, Honorable Chair. So that's what. Yes, I just want to also remind ourselves about this particular act. Yes, Honorable Speaker or Chair, I just want to remind ourselves about this particular act because this act shall apply to all public bodies, B, public authorities and non-state bodies, and C, private organizations or private persons. So realistically, it's not only affecting, government institutions only. So we need to take that into mind. So the private sector are also part of these laws. So we need to be careful because of some of the information they hold. Okay.
So, thank you very much, Honorable Chair. Honorable Chair, the reason why we should really consider the lenient, to be lenient, is that somebody can procure the service of a young boy or young man to break into an office, get a document for you. That person could be charged for obstruction of the work of the commission. And then what are you telling us? That the fine is either 100,000 and a young man from the streets. That means you are sending the person to jail, making the person a criminal. So these are the instances that person is not free from liability. So that's the reason why we need to be very lenient with and as the minister rightly put it.
It's not referring to.
There is latitude. No, you can procure, a young man who is 18 years and above, to go and break into an office to get you a document.
Will take into consideration the age.
No, not a young boy. Who's 18 years? Who's liable for conviction? Who 18 years and above, A young man from the street, You know these young people, you can go and then hire their services to break into an office, get you a document. That guy is liable. It's an offense. So what are you telling me? If you put the fine at $100,000, the guy cannot pay it, that means he should be taken to jail. And you are
yes, honorable members, I think we have debated and debated and debated. Let us agree on a range and we allow the courts, give them the discretion. As rightly said, I don't think the courts will be compromised as from now on.
Honorable Chair, I have a proposal.
Please, can I land? Thank you. Let us try to agree on a range and give the courts the flexibility, whether it is from 10 or from 50 to 250, and then from, what was it?
Yes. So
2 years to 6 months.
Yes, Honorable Chair.
That's what I'm suggesting. Let me have one or two.
So I get yes, Honorable Chair, and it's not be denied. Address the chair.
Do we? Let's give an opportunity to Opanyomi and then Nyani. They never said anything. Please.
Thank you very much. Thank you very much, Honorable Chair, for giving me the opportunity. Honorable Chair, I think a lot has been said and a range being proposed. I am in support of the range and I have a proposal. Yes, my proposal is from $50,000 to $250,000. That's my proposal. And for the jail term, I'm proposing from 6 months to 1 year. Yes, thank you.
Thank you, Madam Speaker. I also concur with member for Lower South. From 50 to 250,000. Then the jail term from 6 months to 2 years. Yes. 1 year, yes. 1 year, 2 years is too much.
So, yes, like my original proposal, from $10,000 to $250,000 and from 6 months imprisonment to 2 years, without the both.
proposal will be from $50,000 to $250,000 and a jail term of 6 months to 2 years.
Yes, I propose my original from 50,000 to 250,000, 6 months to 1 year. I agree with the Lamyam and Nyamina. 1 year. Thank you.
Not you, this one.
Let's take a vote now.
Chair, as per the procedure, all those are proposing, most of them, they haven't submitted anything. So those things cannot be considered. The ones that can be considered are the ones before you. So it is better for them to write and submit. If not, we are going against the procedure.
We have received proposals. No, we have received proposals from 250, 10,000, and 50,000. We have received proposals from that. We have also received proposals from, sorry, 50,000. Okay, 50,000 was from Iliasa, minimum, Musumbana, 250,000 to 64, 50 to 50, 6 months to 2 years. So these are here. From 100,000 for 1 year. So I think we can narrow this down. Also, we have 50,000 to 250, 6 months, 1 year, 50,000 to 250. So let's say the 50,000 to 250 appears to be,
I am saying, Honorable Chair, some of these proposals, they are already the same, if you take into account. So maybe you can distinguish them and see the ones that are talking of the same thing. Then we vote onto them.
That's what I am saying. These appear to be on the same line with 50,000.
We can vote them.
50,000. And then the difference here is 2 years and 1 year. But the 6 months is agreeable. I need to be clear so that we know how to put the votes.
Vote on this.
It's either 2 years or 1 year.
2 years, 6 months.
So do we take a vote on this, on the figures and the imprisonment term before we actually take a vote on the amendment? Huh? Okay. Now, it is proposed that the term, the fine, the range for the fine be from, what's this? Between 50,000 to 250,000. That appears to be the consensus. No, but we were deciding on that before we actually take a vote on the amendment. We were deciding that as a result of the discussions, preliminary discussions. What do you say? Let me hear you. No, we are deciding on the preliminary discussions that we had between 50 to 250 to give the magistrate
It's 10,000. You said the lowest is 10,000.
Yes, I think only very few people say 10,000. So that's why we are trying to compromise and say, okay, instead of saying 100, we can go to 50 to 250, at least to balance it out. Yes, of course. Up to magistrate. Yeah.
We have more than 50,000 as opposed to 10,000. The 10,000 suggestion came from the Honorable Member for Serekunda, but he appeared. Yeah, it is in the act, but there are other proposals, Honorable, with all due respect. There are other proposals. This is what is contained in the act. Fine, but there are other proposals. So we have to be guided by that. So, honorable members, do we go in for 50,000, the range from 50 to 200,000? Pardon? 50 to 250. 50 to 250. Yes, okay. Then the jail term, 1 year, 6 months to 1 year. 6 months to 1 year. Okay. So now we can safely say that we will propose, that it is proposed that clause, oh my God, clause 76 stand part of the bill with amendments. 50 to, they will do the necessary drafting. Honorable Minister, 50 to 250 and 6 months to 1 year. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. It is proposed that clause 76 offenses now stand part of the bill with amendments.
Clause 77, funds of the commission.
Part, sorry, the honorable members, I have seen, if you go to your page 46, I think that probably was a typing error. It already has part 1, 2, 3, part 8. It already has part 8. Either that or the numbering will have to be amended accordingly. Even going back to, you have part 5 on page 31. Then you have part on page 36, part 6. That's correct. Then on no, please, can we have just a second? I just observed something so that it will be corrected. Look at your part 46. You've seen it. Yes, 46 should be part 7 instead of 8. 47. Sorry, page 46, not 47. 46 should be part 7. That is appeal to the commission. Because you have another part 8. Where is it? Financial provisions. So it's the other one that should change. Have you seen it? Yes, okay. Thank you. Where were we? Financial provisions. So it is correct, financial provisions is on the part 8. It's the other part that should be changed. The 7, instead of 7, 8. I mean, instead of 8, it would be 7. There was an error there. Clerk, can we continue with the financial provisions, please?
Clause 77, funds of the commission.
It is proposed that clause 77, funds of the commission, stand part of the bill. Any observations? Yes, Woolley East. If you have observations, let's...
Yes, Chair, my observation is 77B.
Sorry,
where gifts are mentioned. I'm not in support of gifts. I'm in support of donation and grants, but not gifts.
Did you put it down? Okay. Yes, you are not in support of gifts.
Be prone to...
And there is also another observation, amendment from
Me.
Woolley
West.
or Woolley West, okay.
To make it uniform, the
Just
first
a
one is
second.
better.
Woolley West, 77B, it says any monies, is it? Received by the commission by way of donations, gifts or grants from any legal sources, whether domestic or foreign. And his proposal is EYS instead of NIES. Monies with EYS. Okay, I think that can be, we can agree on that. But let's take the one with more substance from Woolly East, which is the gifts. We want gifts to be deleted. You have not proposed, put that in writing. Did he? Okay. That gifts should be deleted from B, 77B. Any observations on that? Yes, she's coming up. Please, honorable members, next time let's try to do these things ahead of time. Thank you. (77B) where is the and okay to add undisclosed to the National Assembly after the word and. Any monies received by the Commission by way of donations, gifts or grant from any legal sources, whether domestic or foreign, undisclosed to the National Assembly. That's your proposal. These are the two proposals. We delete. It is proposed that the word gifts be deleted from the section and also the phrase.
I'm questioning that. I'm questioning that. Yes. No. I want to ask you, Madam Chair. Yes. In your view, what is the difference between gift and donation? Gift and donation, what is the difference? Yes? I want to... No, but, okay, to be serious. No, don't ask him. No, to be serious. The difference is nothing. There is no difference between them semantically speaking. You give somebody something and you donate somebody is the same thing. Is the word is the meaning is the same. So if you are deleting because it is giving out, what about donation? What about grant? Grant is also giving out for free. You are just giving all these things. All the three are almost the same thing. You are giving out for nothing. You are helping somebody with a gift. You are helping somebody by donating. You are helping somebody by giving him or her a grant, a government. Because government is big, you don't give to them, but you grant to them. You don't donate to them, but you grant to them. But grant, donation, and gift, same, pas de différence.
That goes for him. He's again.
No?
Contributions. I have a question.
It almost come to this. Well,
So,
West, your microphone. Only West, your mic, thank you.
So yes, I am convinced by the honourable member for Woolly West, on the nomenclature of donations. However, if you read the section, it says the funds of the commission shall consist of any monies received by the commission by way of donations, and I want to suggest to replace gifts, and put in loans, because the commission can attract loans and grants from any legal source, whether domestic or foreign. So yes, so the word donation can go, the word gift can go, and put in grants, loans and grants.
There's no proposal. It's oral. I have not received anything from you. Where is his proposal, he says?
On the B1,
I hope you did not drop it.
is attached to proposal.
Oh, he attached it with his previous proposals. Oh, sorry, it was attached to the previous proposals. So your proposal, you haven't. You haven't. The proposal from Banjul North reads, I propose contributions in place of both donations and grants. So do we agree that donation and grants be deleted and then replaced by what?
Honorable Chair, now what I've written is that I am proposing contribution in place of donations and gifts. I want grant to stay by way of contributions and grants. And I don't think loans, we should entertain commissions taking loans. I just don't know. If it is for salaries, yes, like government late allocation, but I don't want loans to be there. That's my feeling. I am saying instead of, I agree with the Williams that grants and gifts as opposed to, Willie is transfer. They are the same. They are the same. Grant comes in their place. Grant is fine, but instead of having the two, we put contributions.
To get you right, your proposal is to delete donations and gifts.
Yes.
And leave grants.
And replace the two words with contribution. By way of contributions and grants.
By way of contribution
and grants.
And grants. Sorry.
Thank you, Honorable Speaker. First of all, the first proposal that says when after the end of the list to say whether from domestic or foreign source to be disclosed to the National Assembly, I don't think that is necessary. If you go to section 78(4), the audited accounts of the Commission and Auditor General's report on those accounts shall form part of the Auditor General's overall annual report to the National Assembly. That audit report will show you the sources of their funds. So you don't necessarily have to put it there, up there, that they should disclose their gifts and whatever. That will add another layer of bureaucracy on them. You will definitely have access to the sources of their income when their audit reports are tabled before you. So I would discourage that. And then coming back to the issue of donation, gifts, grants, this honorable member for Woodley West is right. They are all, is the context in which you use them that differ, but they all saying the same thing in a different way. So you are better off for drafting purpose keeping all of them than removing one in better word for the other. When donations are used appropriately in a different context, gifts can be used to describe a different context, grants can be used to describe a different context, but seriously, they all mean the same thing. They are all meaning a willing party who is willing to give something with no conditions. It's free of charge. Grant is supposed to be a gift. If conditions are there, that depending on your negotiations, but once it is called a grant, it's supposed to be given. All right, I know in the diplomatic world, grants go with conditions and negotiation, but we are looking at the literal meaning of the words here, not what really obtains in politics or in international relations. If I give you a grant of something, I'm giving it to you. All right? So we are better off keeping all of them and not to make this provision add another layer of them having to disclose this to the Assembly. It will be disclosed to you appropriately under another provision. So loan, let me comment on loan. Loan, I stand to be corrected, but cannot be described as a source of revenue for anybody. Loan is a temporal measure. Borrowing, it's not a source. It's not. You're borrowing to use it for a purpose, and when your rightful source comes, you pay it. So it's not a source. Loan is not a source of revenue. You are taking temporary to deal with the situation because maybe your sources are dried up or they are not yet here. So you cannot list it as a source. In fact, you're going to take it from your source to pay that loan. So loan in itself is not a source of revenue.
I just need clarification. Thank you, Honorable Chair.
I'm not sure whether you still want the floor. Okay, sorry about that. My attention was...
Thank you. So I just want clarification on this now. Fine. Bank facilities. I understand that some of these commissions run a different bank account. And sometimes within their operations, they might be needing facilities from the bank, whether in the form of overdraft or a loan. But I just want to know, while we are trying to pass this particular provision or to consider, is that not going to constrain their operations should the need rise?
Well, I don't know. Those facilities are liabilities. Here we're talking of sources. So for me, the qualification there from any other legal source will be fit. I probably would, if you want for the purpose of listing and exhausting the list, returns on investment could be a source, for example. If they invest, by merely simply depositing the money in an interest-bearing account, will return them some form of interest. So return on investment. But for me, that will be catered for when you say any other legal sources, because you may not be able to exhaustively list all the sources of revenue for them. So you list few and then say any other, so long as that source is legal. Probably maybe you add that that is not inconsistent with their mandate. Sometimes we do add that when you are dealing with this kind of institution, so that you don't allow them to take money from sources that will conflict with their mandate. Maybe you can add that for cosmetic purposes.
Yeah, but what you just suggested now is covered under Section C. Subsection C, you'll see, like
proceeds from sale, lease, transfer,
so those can be profits as well, from interests, from their accounts.
That's not covered under C. C is saying proceeds from sale, lease, transfer of movable or immovable property. I'm talking about returns on investment. That could be covered under B, under any other legal source. Yeah. So probably with my intervention, Madam Speaker, do we actually even need any changes here now anymore? Because the two proposals that I'm aware, unless I miss something, is to make B to add that it will be disclosed to the Assembly, and also we were struggling with whether to delete gift, bring loan, that, and I think it's the way it is drafted, it's covered. It's not meant to be exhaustive. Any other legal source is available to them as a source of revenue.
Proposal for it to
the objective is to capture all the sources for funding, and we've captured the appropriation by the National Assembly, we've captured donations, we've captured gifts, grants, and monies from any legal sources. Any legal source covers everything else, whether foreign or domestic. So it seems that it captures everything.
It's captured. Are you saying it's not captured?
I say it captures all the sources
all
of
the
funding.
sources.
Yes. I want the minister to look at B. When you say donations, gifts, or grants from any legal source, we are only talking about those ones. It's not talking about others. I think we have to put an or after grants, or from any, or money from any legal source. The or must be there for other matters to come in. But as it stands now, it's just donations, gifts, or grants. from those ones from any legal source. If they are coming from a legal source, that's what it is saying.
I agree, but I think that is what is intended. You can receive, remember, when it talks about appropriations of the National Assembly, it is deemed that is legal. That's why that word did not come to describe that one. So agreed, from legal sources, here is adjectival. It is describing the donation, gifts, and grants. And then that brings us to what we just left, whether then that legal source will qualify complete the listing, because we are doing a listing here. So any monies received by the Commission by way of donation, gifts, or grants from any legal sources, whether domestic or foreign. Or maybe or from any other legal source. We will reward this quickly. Is this the last point for us? I'll quickly check.
Do we agree on that then? Or from any?
I think then you will see that that will then from any other legal sources.
Can I propose something? Formulation. B. Madam Chair. B, if we just simply say, yes, if you just say, but since they are being left there, by way of donations, comma, gifts, comma, grants, comma, or from any legal source. Or from any legal source. This O here should move from there to, okay. You refer to it. Clause 70, what is it? 76, 77. Okay.
So, Madam Speaker, I just try to revise it quickly. Any monies received by the Commission by way of donations, gifts, grants, or monies from any other source, or monies from any other legal sources, whether domestic or foreign.
Thank you, but I want the proposal to confirm. Honorable members.
I can read it again. Any monies received by the Commission by way of donations, gifts, grants, or monies from any other legal sources, whether domestic or foreign.
Do you need to repeat monies?
Or from any other legal sources, whether domestic or foreign. Yes. Thank you.
There was a question that Serekunda posed. What was it? Whether we need?
We captured their concerns now. I can read it again for the records.
Yes.
Now I'll read the whole section. Funds of the Commission. The funds of the Commission shall consist of A. Such monies as may be appropriated by the National Assembly pursuant to an Appropriation Act for the purposes of the Constitution. B. Of the Commission, sorry. B. Any monies received by the Commission by way of donations, gifts, grants, or from any other legal sources, whether domestic or foreign. And C. Any proceeds from sale, lease, or transfer of movable or immovable property of the Commission.
From Honorable Member for Woolly is donations, gifts, grants, or money from any legal source. No. Yes, I think we're better off with that drafting to take care of all this from a legal source. So I will delete that. Thank you. Thank you very much. Thank you. So it is proposed, honorable members, that Clause 77, funds of the Commission, stand part of the bill with amendments. Those in favor, please say aye. Aye. Those not in favor, please say no. The ayes have it. So the clause 77, funds of the commission, now stand part of the bill with amendments. Can we proceed? Thank you.
Clause 78, estimates, accounts, and audit.
Thank you very much. It is proposed that clause 78, estimates, accounts, and audit stand part of the bill. Any proposals? Did we have suggestions? Comments, observations? Honorable members, on clause 78, the estimates, no? Chair?
We are okay with it.
Yeah, okay. Thank you very much. It is proposed that clause 78, estimates, accounts, and audit stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 78, estimates, accounts, and audit now stand part of the bill.
Clause 79, annual report to the minister.
Thank you very much. It is proposed that clause 79, annual report to the minister, stand part of the bill. Any proposals, amendments? No? Clerk? Sorry, Chair?
Yes, the committee suggested for the National Assembly to be added, where it says the Commission shall not later than 3 months after the end of the previous year, each year submit to the Minister and the National Assembly a report of its activities in the previous year.
Yes, I can see the tags of the Public Enterprises Committee members. Yes, Serakunda and then Banjul North.
Well, I think we've covered it already in another section. That is the submission to the National Assembly, unless we want to draw it here. But in terms of the submission to the Minister, the Commission shall not later than 3 months after the end of each year. So under the Public Enterprise Act, it is 2 months. So it should be brought into conformity with the Public Enterprise Act. But the National Assembly, we've covered it.
The page, on page 40, I just saw it, 45, CO 45. 3.
Yes, we have covered that. I said we have covered it somewhere.
Somewhere, that's what I'm saying. I said, I think this is one of it. I'm not sure whether there's an earlier one. On page 45.
Yes.
Look at 3. All public bodies shall incorporate the report submitted to the Commission under this Act into their annual reports to the National Assembly. I'm not sure whether that's what you're referring to.
Yes. Within 3 months, yeah.
Within 3 months after the
I had seen it earlier on.
that was amended.
It's somewhere.
We had the amendment.
Oh, it was amended. Ah, okay. Thank you. So it's covered. There is no need. Clause 7, it is proposed that clause 78, sorry, 79, sorry, annual report to the minister stand part of the bill. Those in favor?
With amendment.
But I thought you said it's already covered somewhere.
Yes, I'm saying what he wanted to put there is not really necessary. But this is the report to the minister, not report to the National Assembly.
Okay.
79. So the annual
So what
report,
is the amendment?
it should be 2 months instead of 3 months.
2 months.
Yes.
See, can you, sorry, put it down in writing again. Thank you. It is proposed that clause 79, annual report to the minister, stand part of the bill with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 79, annual report to the minister, stand part of the bill with amendments.
Clause 80, regulations.
Thank you very much. It is proposed that clause 80, regulations, stand part of the bill, we've received some proposals. One, that it is from Upper Fuladu West, that clause 80, the whole clause to be deleted. His reasoning is powers it gives to a minister, a political appointee are overboard and intrusive, taking over the independence and autonomy of the commission as provided for in clause 48 of this act. This is from Latikunda Sabiji. The commission shall, within 3 months.
Sorry, we have passed that one, it's okay.
Pardon?
We have passed that one.
Oh, we've passed this.
Now, but it's okay.
But the committee
have taken care of it.
reading it, I was just going to say, but
It's okay, but the committee have taken care of it. Yes, sir.
Thank you. So we're dealing with the regulations. The proposal from Fuladu is for it to be completely deleted. Yes, any?
Let him explain why he wants us to delete it.
I think you just read my explanation, but anyway, I can still explain. I just think, it contradicts Section 48 of the Act, because Section 48, any independent or autonomous body is given the commissioners, called the commission, the independence for them to regulate themselves. But here it is given the minister the powers to regulate, and again, that was my point I was making. It can affect their salaries, it can affect their fees, even their terms in office. So if a minister can just sit over after an act of parliament and change the whole arrangement through regulation, I think that is very intrusive.
Yes, thank you, Honorable Speaker. Maybe when I come early, it will guide the debate. Yes. Number one, I need to correct that. There is no contradiction. Autonomy is relative. The autonomy is granted by National Assembly. It's the same autonomy that is given the power here. So that cannot be contradictory. Then the other thing is, this concept of regulation, we need to understand how regulations are made. It's not a minister. All regulations goes to cabinet for approval. So it's not a minister sitting conveniently to do regulations. All government departments participate in regulation making because it is the operationalization of the law. And in that case, government institutions that will be affected in the implementation are consulted, and every regulation goes to cabinet for approval, because that is the operational arm of the law. And in as much as we want to control the powers of the ministers, we need to also appreciate the fact and also realize the separation of powers. It is the executive that implement the law. So there are certain implementation requirements. The executive too need to have a little bit of latitude there. So for me, you can control the framework of the regulation. I have no problem with that. For example, if you think the minister might intentionally or cabinet might intentionally put their remuneration so low, then you can cap it. You can say that the remuneration should be pegged to sister commission, not below similar commissions in the country, so that it's guided. But to say completely the minister should not make regulations and removing the whole regulatory framework, that will pose implementation challenges of the legislation.
Can I say something?
Yes, the minister forwarded a very good argument. However, will we agree that even whereas now you want to extend such regulatory powers to the minister, this can be prone to abuse, as he just rightly mentioned now. And therefore, it begs the question again. When I was defending the Section 47 about the remuneration of the commissioners, this is not what my fear was. I'll give you, just allow me please to give an example. If the executive is not happy, with the conduct of the commission in terms of giving access to people that they don't want to have access to information to people that they don't want to have access to, the executive can decide there and then that we need to penalize or dampen or restrict the effectiveness of this commission by imposing such regulations. So here, how fair or how secure is the tenure of office of these commissioners? We're trying to defend the tenure of office because, like the Honorable Member of Serekunda said, these are going to be a sacrificial service to country. Most people will leave their jobs or in the private sector to come and serve the country, but they have no tenure, security of tenure of office. They have no they have no independence, from the executive. Whether it's the Human Rights Commission, whether it's the IEC, if you are prone to abuse, even as slightly as it is still a window that can be utilized. So that's my fear.
The issue is about regulation. And he said the minister may make a regulation for carrying into effect the purposes of the provisions of this act. It said without prejudice to the generality of subsection 9, regulations may provide for term of office, salary, and allowances of the commissioners and staff of the commission. So it seems the member is saying, well, this is not safe to leave this responsibility to the minister. Then who would actually determine the term of office, salary, and allowances of the commissioners and staff of the commission? Well, it says that the minister will have to get the approval of the National Assembly. Isn't that what we have approved? So it means that, well, it's not totally in the hands of the minister to do that. So should that be a regulatory power of the minister? I think that is the question. The fees for requests for information and the manner of payment. Well, should that be the responsibility of the commission or the minister? Fee for reproduction. Should that be the responsibility of the commission? The manner of publication of any matter? Well, Honorable Chair, I think maybe where we should stop is the minister may make a regulation for carrying into effect the purposes of the provision of this act. Maybe we should stop there and then delete the whole of 2 unless the Honorable Attorney General can convincingly indicate why it is necessary for the minister to have these powers by way of regulation.
Ask a question for my own understanding. If I look at clause 47 on page 34, it clearly talks of the remuneration of commissioners to be approved by the National Assembly, of course on the recommendation of the minister as stated. Now, how can I reconcile that with regulations? That's just what I want to understand. Yes.
So,
I think you understand what
I will just connect it from the Honorable Speaker. Thank you. In fact, I was going to say that we don't even need A as a regulatory requirement. Section 42 or clause 42, 4 already stated commissioners shall hold office for 5 years. I don't know whether this was amended, and eligible for the appointment. So their tenure is already legislated. Their remuneration is also legislated. So A is not a matter for regulation. What could be a matter for regulation could be the fees for request, reproduction, those kind of things which are flexible and may change depending on different circumstances. Those ones could be regulated, and the manner of publication of any matter under the Act. In fact, if you remove A, you now have these 3 wish lists, which are just a guide anyway. They are meant to guide when the minister is making the regulation, not necessarily so, because of course any regulation will have to talk about the fees, the minimum cost that could be imposed for the production of material and requests for the information that needs to be paid. Usually these are not legislated in the primary legislation. They are a matter for secondary legislation. But of course A must be deleted completely because it's talking of term of office and remuneration, and these things are already legislated earlier. Yeah.
On the floor. I think in future we'll need more people so that they can assist in, especially during consideration stage. He's sleeping. Your suggestion, your proposal is the same. Okay. It's the same. Yes? Serekunda, are you okay?
Sending just an addition. Can we? So what I'm proposing, Honorable Chair, is that fees for requests for information and the manner for payment as determined by the Commission. We add fees for reproduction as determined by the Commission. The manner of publication of as determined by the Commission. I think if we put that as determined by the Commission,
the Commission will be
will be the determining authority
in the decisions. So there's a suggestion or in consultation.
Well, consultation is not safe. I think the Honorable Attorney General understand well my understanding. Consultation is not necessarily consultation as we understand it.
So, yes.
Thank you. So basically, I agree with honorable member of Serekunda, but then that would not, in effect, just devolve the powers of the minister again. So it comes back to my point, because if autonomy is going to be determined by the commission, then the ministers, if the commission doesn't determine it, then the minister cannot carry out with those regulations. So in effect, just nullifies his power. Am I correct or wrong?
It only means that for that portion of the regulation, the minister have to receive it from the commission and include it in the regulation. Because there may be other issues of regulatory need that the commission may not be doing. So, but when it comes to fees and manners of paying, this suggestion is to the effect that when the minister gets there, it's like hands off. Just ask the commission to submit it and you incorporate it in the regulations. Yeah.
The proposal is for B. Okay. The proposal first is for 2A to be completely deleted. Agreeable? And then the second proposal is B, fees for request for information and the manner of payment as determined. Am I reading you correct? As determined by the Commission. Can you help me with this? This is B. Okay, it's C. The same for C and D, to add as determined by the Commission. In both C and D, in addition to B. That's what is being proposed by Serekunda.
If the minister agrees, just...
Fortunately, I cannot go to collect the proposal from the honorable member.
It's a bit difficult to disagree with this proposition, so...
And then the minister may make regulations for carrying into effect the proposals of the provisions of this act in consultation with the commission. I think this is where we can put in consultation. That's 1. 81.
Regulations for carrying into effect the provision, the purposes of the provisions of this act. Now your proposal is
in consultation.
This act in consultation with the commission to be added there.
Yes.
And Woolley is suggesting that rescind on decision, is it? Oh, you've given it to, we've corrected it. It's for the previous one. Is to include at the end of this act under subsection 1 in consultation with the commission. Are we agreeable? Okay. Thank you. So now, you've drafted, yes? 50, let's take the vote on 80 first. Okay, thank you. It is proposed that clause 80 regulations stand part of the bill with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Thank you very much. Then, then we have the objects and reasons. You have any observations on the objects and reasons? The last page?
Yes.
Yes?
The name of the minister should change, I think, I think it should have his name, instead of the former minister, the Minister of Information.
That's what I was thinking. In fact, I was thinking that they would be here today. I was expecting the sort of information team to be around. So what is the concept? Justice tabled it. I remember that vividly. Views, please.
So what is the minister suggesting?
No, he is suggesting that we change it from Minister of Information to the Honorable Attorney General, who actually tabled it. Yes. So if, in addition to that, do you have any observations on the content of the objects and reasons? Yes, Woolley is.
The first line, this bill seeks to provide the framework for ordinary Gambians. I was thinking that we just remove the ordinary. Because I think even non-Gambians can benefit from this bill. So if we just say ordinary Gambians, it's like we are limiting it. to everybody, not to include everybody.
Proposal is to delete ordinary. Clear on your proposal.
It's saying ordinary Gambians. I don't know why it should be limited to ordinary Gambians to benefit. We ordinary Gambians, I think everybody should benefit. That's what I'm saying. It should be open to everybody, Gambians and non-Gambians alike.
So you want non-Gambians?
Yes, Gambians.
No, I don't know. That is why I am.
No, I'm telling you, yes.
Can I say something? Can I, Madam?
We take out the ordinary and say Gambian.
Okay, choose one of them. Me. Okay.
I say we take out the ordinary and just say Gambians.
I say Gambians. Just put it down in writing. Thank you.
Put it down too. I say you will ask me to put it down too. You see, Madam Chair, language is a loaded weapon. It's a loaded weapon. I say language is a loaded weapon. Like a gun, you load it. Huh? You see, we use words, but we don't take into consideration what actually we are talking about. Like when you are building a house, you don't just take any block and put it anywhere. There is a block meant for every place. So when you say for ordinary Gambians, for me, you have divided Gambia into two. Those who are ordinary, those who are not ordinary. Who are not ordinary? Why not just say Gambians, for Gambians? Simple as that. You see, Madam is not ordinary, maybe.
Madam would have just simplified to say, please, I am proposing the deletion of the word ordinary. And then we progress. Should be deleted, okay. Good. The proposal is for the word ordinary to be deleted, just to read Gambians. Thank you. So,
another proposal which I have forwarded. The last sentence. The bill provides for the setting up of an independent commission to ensure that decisions on the disclosure of government information should be reviewed independently. I think we're trying to capture non-government institutions as well. No? So it should have both government and non-government.
Public or non-public capture. You mean this bill will be applicable to private sector?
No, check page 6. That's what you brought.
Where?
It's your bill. You brought it here.
Yes.
Page 6. If you look on 3
clause
application clause 3C. 3C.
Apply to all public bodies, public authorities and non-state bodies which are owned or controlled by the government, private organizations or private persons who operate with substantial public funds or benefits directly or indirectly from public funds.
So it remains the same, Madam.
Or who perform public functions and services using public funds.
Yes, it's still public interest.
Public.
Even if it is applicable to the private sector, is to the extent that they are involved in dealing with public funds or public activities. So this is primarily for public government, public institutions. It's only applicable to private institutions to the extent that they are involved with public interest issues. Yeah, so still it's just applicable to the public bodies.
So I think they should change the government to public information, because we're talking about actors or stakeholders outside the government setup. Government is like you said, is a loaded word.
Because I remind you of Honorable Willie West's example earlier. A private citizen destroying somebody, what do you say? Somebody is demised, and the child's documents are in somebody's custody. This bill, mark you, would not be applicable to that situation. That person may be guilty of committing another crime, but not under the access to information bill, please. It's not meant to deal with private transactions.
We retain government information.
Madam Chair, I'm proposing, like he rightly said, yes. Let's say we have a private telecoms company whose license contracted by the government to provide a service. Like you said, they're using public funds, and therefore they should be in the position to give information where requested. So if you say government, those people are not government. They are contracted by the government, but they're not government. So therefore they cannot use this provision to say we are not government. That's my fear. So I just wanted, if at all it's not going to be a problem, why not we just change the word government to public information, no matter where who is the custodian of that public.
But if you look at C on the 3C, even though they are private organizations or private persons, if they operate with public funds, it's taken care of, I think. It's captured, unless you want it for emphasis.
Yes. It makes no harm replacing government for public, but that private entity, to the extent that you are asking for that information from them, you call it public or government, but the information is either way. What is government information is still public info, but I understand you want it broader. So public information is fine. It's not a problem. I don't think it will affect the meaning.
Okay. Any more proposals? Can we have the please, Honorable Upper Fuladu? Can it be written so that it will form part of the records? Thank you. So it will be redrafted to incorporate that. So it is proposed here that objects and reasons of the bill stand also part of the bill with amendments. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. And the objects and reasons now stand part of the bill as well with amendments.
Yes, Honorable Chair, and the Honorable Chair.
From where? Yes.
Yes, and also the first page, the arrangement of the sections. Arrangement of the sections. You have you have part 1, part 2, 3, part 4, 5, 6. There is no part 7 in the content. Yeah.
Thank you. In fact, I had earlier on referred to the page, relevant page, but I can't. I did it. Can somebody please help me? Page
67.
57.
667.
I think I'm more comfortable with the page.
No, it's not 67. It's
good. If you look at page 46, you have part 8 on page 46.
46.
But then if you come earlier on, don't just hold on a minute, I will get it.
Page 46, you have part 8, and then you go to page 51, you have part 8 also.
Honorable, I think
Yes. You're looking for?
It's part 8 and part 8 again, financial provisions. That's on page 51. That's page 51.
on page 51, yes, I drew the attention of the
Yes, Part 8 financial positions.
And again,
51.
Part 8, appeal to the Information Commission.
Yes, so those are Part 8, so the sequencing needs to be changed.
So that will have to be
Part 9.
corrected. You have the powers and duties of the Commission on page 36 as Part 6. So then the first Part 8 on page 46 will now be Part 7.
Part 7. Yes.
Yeah.
Expected as such.
And then, of course, Part 8 will be the financial provisions. So it's proposed that those amendments form part of the bill. Those in favor, please say aye. Those not in favor, please say no. So those amendments now stand part of the bill. They as amended. Thank you. So now, Honorable, we come back to the two, Chair.
Guli is with you, the one I sent to you.
The one I sent to graduate is with you. It is dealing with the subtitle.
I think we took a vote on that. Yes, we did. We did. I don't know whether you stepped out or not. We've already taken a vote to delete ordinary Gambians from the objects and reasons.
No, I'm talking about the short title of the bill, of the bill. The act may be cited as
during the commencement of the consideration stage. It was amended.
from 2019 to 2020, but now we are in 2021.
So it is proposed that clause.
Madam Speaker, Honorable Member is right. The last time we were here was on the 14th of July 2020 on this bill. So I think even if it were amended, we would have amended it to 2020 at the time. So now we are in 2021. I think he is right that it should be updated to 2021. Yes, according to my date, the last time we were here was on the 14th of July 2020. So it's almost a year we have not come back on this bill. Yeah.
I remember that was when I was sick. Yes, I remember that long period. Yeah, and the deputy speaker was chairing. Yes. So it is proposed that what is the clause again? That clause 1, the short title, stand part of the bill with amendments. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. So clause 1, short title, now stand part of the bill with amendments. Thank you. So we now go back to the suspended clauses. 52. Okay, we start with 52.
Thank you. Thank you, Honorable Speaker. This is the revised draft of 52.1. The Commission may, whenever it deems appropriate, appoint experts to assist in the gathering of information, conducting research, investigation, analyzing issues pertaining to the performance of any of its functions under this Act. 2, in appointing, okay. The Commission may, whenever it deems appropriate, appoint experts to assist it in gathering information, conducting research, investigations, and analyzing issues pertaining to the performance of any of its functions under this Act. The Commission may, whenever it deems appropriate, appoint experts to assist it in gathering information, conducting research, investigations, and analyzing issues pertaining to the performance of any of its functions under this Act.
Honorable members, 52-1.
What can you shall?
Where is mentioning function? The word function should have an S, making functions.
In such experts, the Commission shall include qualified representatives from appropriate civil society and other interest groups. Yes, if they have to
Second reading.
In appointing such experts, the Commission shall include qualified representatives from appropriate civil society and other interest groups.
Can an honorable member propose that this Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. So clause 52, engagement of experts, now stand part of the bill as amended. Thank you. 53.
Thank you. 53.1. 53 is immunity of commission and staff, the one that we were looking at earlier. So 53.1, the executive secretary, that is the new drafted one now. The executive secretary, the staff of the commission, and members of the commission shall not be subject to civil or criminal proceedings or be personally liable for any act done or omitted to be done in good faith in the performance of his or her functions. The Executive Secretary, the staff of the Commission, and members of the Commission shall not be subject to civil or criminal proceedings or be personally liable for any act done or omitted to be done in good faith in the performance of his or her functions. Or I could say their functions, because this reading is, performance of their functions, yes. Actually, what the departure here is, the immunity as provided under the ones with you was shielding the commission from lawsuit. And the intention wasn't that. The intention is the staff, as they carry out their work in good faith, commissioners and staff, as they carry out their work, they should not be personally liable for their acts or omission, so long as they did it in good faith as part of their job for the commission. Right? So that is what we brought out. That is the kind of immunity we normally give to institutions, the people serving in this institution. Because by virtue of your work, and so long as you are acting in good faith, you are not supposed to incur any liability. But the test is the good faith. If you abuse your office and go what we call the floric of your own legs, then whatever you get, it's what is your own thing. But generally, if you are a servant of the commission, or you are a serving member of the commission, if you are acting in good faith, you should get some protection of the law.
Any observations on the new draft? Chair, honorable members? Okay. Then we go to BM2.
We've not touched 2. Okay. 2 basically is protecting a whistleblower, because it's saying a staff who discloses wrongdoing within the commission may not be subject to any punishment in the course of their employment by reason of the disclosure. This is a protection for a whistleblower, but the protection too is only limited to internal disciplinary measures. So if somebody within the commission blows the whistle of something wrong happening within the commission, the person cannot be liable to administrative punishment within the commission for the fact that he has disclosed a wrongdoing. Basically, that's what it is saying in sub 2. That's generally protecting a whistleblower.
Can I get proposals from honorable members with regards to?
Yes, so I propose that section 53 stand part of the bill.
Be amended.
With amendments, yeah.
Thank you very much. It is proposed that clause 53, immunity of the commission and staff.
I mean, I suggest it's not the commission. Immunity of the members of the commission and staff.
Yes, but the proposal is that include, it's going to be amended.
Yes, so we will amend the title to reflect the content.
Yes, so I think I was right.
Yes.
Clause 53, immunity of the commission and staff stand part of the bill as amended.
Yes, but we will amend that heading.
As amended, yes. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. So clause 53, immunity of the commission and staff stand part of the bill as amended.
Wow, well done.
Thank you. Any more? So, please, we just go up and I pardon? Honorable members, the House now resumes. And thank you. Yeah, I think the ABC, that is the Assembly Business Committee, has scheduled the third reading of the bill for Tuesday, the 22nd of June, 2021. But before that day, the Attorney General's Office and the Office of the Clerk, in accordance with Standing Order 7220, should print the amended version, including all the amendments, for circulation to members before the third reading. Yes. I think it's proper that I now call on the Honorable Attorney General to report, that's the Attorney General and Minister of Justice, the person in charge of the bill, to report to the Assembly what transpired during the committee stage of the Access to Information Bill 2019. Honorable AG.
I'm taking a refresher course. Thank you very much, Madam Speaker. Well, I have the pleasure of informing this August Assembly that the bill, that is the Access to Information Bill 2019, now 2021, has gone through the committee stages and it has gone through some amendments and it is now ready for third reading. Thank you very much.
Honorable Minister and honorable members, if you look at the agenda for today, we have agenda item number 2, which is the Mutual Legal Assistance in Criminal Matters Bill, equally due for consideration. And considering the fact that it's almost getting to 4 o'clock, and I've been sitting up here till 11 o'clock, I mean, since 11 or quarter to 11, I think it is only fair that we adjourn for today and come back another appointed date to start the consideration stage of the Mutual Legal Assistance in Criminal Matters Bill. And on that note, I want to put the question, be it resolved that this August Assembly do stand adjourned till Wednesday, the 16th of June, 2021 at 10 a.m. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. The Assembly now stands adjourned till Wednesday, the 16th of June, 2021 at 10 a.m. prompt. Thank you.